Okay, so we start here. Very good evening, everyone. I welcome here all the audiences from India and international jurisdictions who've spared time for this discussion today. I'm utterly glad to represent Khurana and Khurana IP attorneys. And we have a very distinguished guest today. I've been longing to have this discussion and have the expertise been reflected by Ms. Viji Malkani, Head IP and Food Counsel at HUL. Viji, thank you so much for sparing time and joining us today. This was long waited, and I'm glad you've spared time for us today.
Thank you, Shourabh, and thank you, Khurana, for having me here. It's a pleasure.
Brilliant. So I'll just take the context of our discussion today. It will be intended to have a very concise discussions on prudent aspects of trademark prosecution, trademark trends, on things that happening on international jurisdictions in the EU, post-Brexit in UK, of course, that is one aspect that's been talked about a lot, but there's been lots happening in the international trademark fraternity, be it the US in conjunction with EU, even in Asia, China, Japan, India. There's been lots that's happening for the past a year or two. And especially post-Brexit and with this entire digitized economy that's evolving, it has had some impact on various aspects of trademark filings, prosecutions, and various other trends. So that's what we'll intend and look towards, and expertise coming in from somebody with as illustrious credentials as Viji herself would be extremely important, and will throw some very important light on many issues. So to start with, Viji, I just wanted to have a quick overview of what you believe have been the recent trends that are extremely pivotal from a European, UK, or an India perspective in trademark prosecution or areas of litigation that are coming in. For instance, if I may harp on the fact, there have been a lot of newer amendments in the statutes coming in the US, for example, the Trademark Modernization Act that encompasses newer aspects of litigation grounds, for example, aspects of proof of usage or intent to use. These are aspects that have been really being harped on from an applicability of the statute and an implication from an industrial standpoint as well. Would you want to throw some light on that, Viji?
So sort of intent to use and proof of use was something which was already pre-existing. Even in the US law, you would not get a registration unless you show actual use, and your registration will not be renewed unless you submit proof of continued use. So I don't offhand remember the sections, but there are two sections, I think 8 and 15 of the Lanham Act. So that was always there. And even in India, if you see the recently amended act provides that, when you're filing an application with a claim of use, you need to file an affidavit of use. So things have changed in India as well, because earlier you could just file it on an intent to use and just continue. And, people would not know if you've used, or you could claim any use that you want in your trademark application. And,
exactly.
There was no way of countering that, because it could be, you could even amend your trademark application to add in a use, earlier. So,
yeah.
It could sort of predate your own use, and, which would be difficult to prove. So, but with the latest amendment, even under the Indian laws, you are required to file an affidavit of use. Of course, in most cases, you don't have to beef it up with any evidence, but then, the very fact that you're filing an affidavit, which is a statement on oath, I think that, sort of plugs that gap.
Exactly, and I believe, would you want to reflect a bit on the newer inclusions in the Trademark Modernization Act in the US, which is important from all the contracting states' perspective. So yeah.
Yeah, okay. So, frankly, I think what happens in US, while it's good to follow, I don't think like, it would have much relevance for us in India right now, because, we are still at a stage where we are revamping all our acts. Like, for example, I mean, of course, this is something good to follow. US has come out with a lot of good statutes, like you have the Trade Secret Act, which,
Yes.
which I would
Yes.
believe is something that India definitely should look at and adopt, because, we really do not have a codified law for trade secret, and there are a lot of IPs that really fall within that bracket, which sits within trade secret, and especially because there is so much of focus on MSMEs and small scale industries, which are sort of the engines for the economy's growth. The way they handle IP, it's essential that we have something around trade secret, rather than I do believe that we have ample laws here in India, and the enforcement landscape is quite robust. Of course, there are, there are some gaps and loopholes which need to be addressed, and I'm sure it exists in every country. But in my own experience, as far as HUL goes, I see that the enforcement landscape is quite robust. The judiciary is, quite, they are pretty. We have a very knowledgeable bench in all the high courts, and they're pretty IP savvy, and unless there's something really off the line, we've had a series of good judgments coming out of the Bombay High Court or the Delhi High Court. So I think I think we don't need to like really look at that law for the time being, in terms of at least what has come out in terms of how do you enforce your rights, etc.
Absolutely. I think very, very pertinent point made. Actually, you tend to get drawn towards the new statutes in the EU and the trademark directives and the newer inferences drawn at the European Union level, because there have been a lot of exciting judgments that have come up, be it in the Lego case or the 3D Mark case with Lint Foods, and a lot of other cases as well, which really harps on the new pragmatic judgments that have come in terms of be it the proof of use or having a secondary meaning to establish a good that could be bifurcated between a descriptive or a generic mark. So there have been a lot of evolving case judgments that have come up in the EU, which actually are turning out to be very, very, very important case laws for future relevance. So would you believe that would that have a bearing from a policy or a statute perspective in Indian context, Viji?
So see, like I told you, our landscape is totally different from the EU landscape or the US landscape. The consumers over there or the brand owners over there are more aware. They know about their IP rights and they are more aware. And which is to some extent not the case here in India. There's a lot of awareness still that is required to go in here. A lot of awareness to be done here in India for us to scale up to that level. So while it is like I would definitely agree, there are certain legislation, there are certain precedents that are good to follow in India, and of course they will flow into India gradually. Like for example, maybe the US Safe Shop Act, which is sort of tries to bring in more obligations and responsibilities on a marketplace or an online platform. So those are some best practices to follow, but I do think that the Indian regulators are also sort of rising up to the situation. If you see the latest consumer the e-commerce rules that have come out under the consumer they sort of try to address that gap and put in more responsibilities on the marketplaces or e-commerce platform by trying to build in guardrails at the very initial stage, and trying to be more consumer friendly, which obviously is the objective of the Consumer Protection Act. So I do think that we are gearing up to follow the best practices, and we do have very good, like I said, we do have ample of laws, and we do have a good enforcement landscape. It's just somehow sometimes something things get missed, and it's the execution part that probably needs to be looked at. Otherwise, I think we have enough and more laws and good practices here itself. But like I said, said, eventually the other good things will come in. Now, as regards 3D marks and the non-traditional judgments on non-traditional marks that you cite, I think we still have a long way to go. It was just recently that we,
exactly.
included application for sound marks. So, now while we have provision for a 3D mark, enforcing an infringement on your regular trademark itself, while I again reiterate that the enforcement landscape is good and robust, I mean, but there are challenges, I mean, in even enforcing rights on a simple trademark. And that's basically because judicial interpretation at different levels, different courts will change, and it will be very peculiar to the facts and circumstances of each case. So we do have varying judgments, maybe on similar issues, but, for the courts to rise up to something like a non-traditional mark to deliver the judgment on a 3D mark, I think we'll still take some time, and there is more awareness that is required to go into it, more capability building, even for judges that needs to be done, and which was actually aptly brought out in the National IPR policy of 2016, which the government rolled out. So yeah.
Sure, I think you've very aptly given a very distinctive comparative analysis, and I think it's the gist of it is the jurisdictional or the geographical factors, the socioeconomic factors, and everything trickles. It all comes together and trickles down to a particular statutes and its applicability. So I think that is one of the major reasons. And yes, there are a few more aspects particular to Indian context. I remember reading one of your recent articles on parallel imports and the entire conjunction with exhaustion of IP rights, and how do they create, a troubled landscape, so to say, from an Indian perspective. Would you want to just highlight some pertinent aspects on that side, Viji?
Yeah. So surprisingly, when I was reading the article, what I found is that parallel imports is allowed in many countries across the world. So it's not a peculiar Indian problem. While I would not say that it is the law of the land, because there is nothing that has changed in the statute. But the division bench of Delhi High Court sort of took a view that, India follows international exhaustion of rights, So therefore, parallel imports are allowed. And this matter is sub judice in Supreme Court, which is the Kapil Wadhwa versus Samson case. So actually, there is no final decision in this matter, but in the interim, it's sort of become the law of the land, because the customs allows parallel imports, and generally we believe that parallel imports is allowed. So while it would not be, even if you see the global scenario, and even from a general point of view, it may not be right to restrain parallel imports, because it would be restraint on trade, because there should be free trade of goods across borders. However, what probably is required is some reasonable restrictions on parallel imports.
Exactly.
If I may say, for example, if I could take the example of when you have this surplus sale, when there are export rejects or there is surplus sale, when you go and buy, say for example, you get a branded piece of cloth, you get a top or something. Say, I'm just for example taking, say it says Mango. It's a Mango brand. It's a top of Mango brand. Okay, and you buy it. You buy it knowingly that this is not the original product from Mango. It is a reject or it is an export surplus, and that is why you're getting it at a throwaway price. So that knowledge that the consumer has when he buys, while he knows this is a Mango brand that I'm buying, but he knows that it comes with these certain caveats. So that is what we are saying, is that, because when you have two parallel products of the same brand in the same market, it creates some kind of confusion. And more concerning is that the consumer does not have an avenue to raise his grievance if he finds any defect in the product. While a consumer, for example, if I had to take the example of one of my products, say if we have Dove coming in from UK, and I have Dove products here in India. Now, if there is some defect in that Dove product which has come from UK, I as HUL operating in India will not be answerable to that, and the consumer does not know where to go. So that is one major lacuna in that. In addition to other other disadvantages of parallel imports, if I may say, in terms of the pricing, there will be a price cutting. There will be, brand owners will be disincentivized to put in more money into research, because anyways there is going to be goods that's coming in from across the borders which consumer will prefer over the local product. So there are a lot of downfalls, no doubt, but like I said, stopping parallel imports probably would be a restraint on trade. But like the Delhi High Court has held in two of its, even in the Kapil Wadhwa case, the division bench, while holding that India follows a system of international exhaustion, it did lay down certain parameters and told the defendant to clearly put out that the goods sold by it is, there is no affiliation or association with Samsung. There is no warranty that Samsung will provide, and it is completely their owners. Similarly, it was again the essence of this ruling was also followed in I think it's Western Digital. There was another case law by the Delhi High Court where the judge laid down various factors that the defendant had to put up in relation to the sale of his products, where he could clearly demarcate from the owner and put it out to the consumer that, okay, this is of the same brand, but I'm solely responsible. There will be no warranty provided by the manufacturer here. So those are some of the best practices probably that could be followed, and that the regulators can pick up and come out with a law on that.
Absolutely. I think you've brilliantly summed up the gist of how international exhaustion of rights could be followed, and yet there could be certain caveats that could be raised, and accordingly the primal premise is the source of origin of goods is to be harped on, and that should not be maligned.
Absolutely. And or you could follow the adopt a mid path, like how the US does. It follows the material differences approach. So if there is anything different from what was there on the original product, say even if there is a difference in the language, then that would be considered to be an infringement. The EU, for example, follows a system of regional exhaustion. So within EU, there will be, it is permitted, but anything coming from outside of EU, it will be considered an infringement, and which now would apply to UK, by the way, after Brexit. So earlier, UK was within the EU pool, so anything that would come from UK would be parallel import and would be allowed. But now, if anything comes from UK into the EU, that may be considered an infringement.
Exactly, they're completely distinctive entities, and the applicability is completely separate now. So one question that comes to my mind is, from an Indian context, do you think counterfeit becomes a possible area of concern when you are to imply the principles of parallel imports and exhaustion of IP rights? That's a overlapping menace of sorts, and there are a lot of, India being the kind of the huge market it is, the slightest of loophole and people latch onto it. So do you believe that could be somehow catered to, Viji?
Definitely, counterfeit is a big concern, even in relation to parallel imports. So while parallel imports are not illegal imports, they are definitely unauthorized imports because they are brought into the country without the consent of the brand owner. Counterfeits definitely pose a big concern, because after the division bench, Delhi High Court's division bench ruling, CBEC issued a circular to the Customs Authority saying that parallel imports are allowed. As a consequence, what happens is that while we have the border enforcement rules in place, that is the Customs IPR enforcement rules of 2007 in place, whereby the brand owner is notified when any imports of any when there is imports of products bearing a trademark which conflicts with the trademark that the brand owner has registered with the Customs Authority. What happens now is that if there is a parallel import and they see that it is Dove from the same group company or from Unilever, they will not inform us, because it is allowed as per the CBEC circular. It is allowed, and therefore they will not inform us. So this becomes an easy conduit or a route for counterfeiters to sort of,
Exactly.
get in the counterfeit goods, bundle it with probably some of the genuine goods, or bundle it with some other kind of goods, and get it into the country, and it will go undetected or unreported.
Exactly.
So that is the main concern. And we've
Yes.
seen in some instances, and also the public's we have a penchant for imported goods, right? While I do believe in the past few years it has gone down a bit, but still, the public frenzy for imported goods, still I think it's on a high. And anything imported, we buy it with closed eyes. So that also gives an impetus to counterfeiters to continue
Exactly.
to bring in the goods through this routes. Also, the the emerging scenario, what is a more concern is goods are brought in through free trade zones. Okay, so there is
Yeah.
no level of control in those free trade zones where you could unload your shipment, and then you could pack your pack your containers again with adding more goods into that, and getting it into the country. So that's of more concern. And therefore, yes, definitely parallel imports, we do believe that it does act as a conduit to bring in counterfeits, and that was the larger concern in relation to parallel import, and which we have been
Brilliant.
strongly advocating to the lawmakers and the relevant authorities.
Brilliant. I think you've completely summed it up very, very aptly. In fact, as you were giving the possible remedial measures, I remember reading recently with US coming in with a lot of newer statutes on customs, and that would help thwart any potential infringing goods coming up. I remember reading about a recent Apple EarPod case that was held by the customs purely because they saw primary areas of infringement happening, and it so happened the entire shipment was confiscated. So I think, yeah, so on that grounds, as and when, again, the primal premise remains of how we evolve as a trademark adjudicating country, right from the top courts to the policymakers and the industries at large. So brilliantly, I think that is a prominent issue which we'll closely monitor over the next 4 to 5 years. And with the kind of, I'm sure, with the kind of brands across industries and the product portfolios, the way they've diversified, I think these matters will have to be taken into consideration. And the digital age in itself, it fosters more awareness and more opinions being drafted surrounding the subject. So now we've delved quite a bit on India, Europe, and US. I would want to shift the focus a tad bit to the eastern part, and I would not miss out wanting your opinions on how do you see Japan, China, Korea, this entire eastern industrial powers, especially in context of Japan. I believe they're especially when it comes to US trademarks, they would thwart their entry left, right, center. That's been my analysis over the past 2 years. They tend to be extremely vigilant and very, very aggressive when it comes to litigating or opposing US trademarks coming in. Would you want to just give your enlightenment on this subject, Viji?
Can you just clarify what you meant by US trademarks coming in the last sentence?
So when the US trademarks, for example, be it on all major well-known brands, be it Apple, be it other brands from automobile, there have been a lot of instances cited in the past couple of years wherein Japanese Trademark Office or the JPO in itself completely outrightly denies any applicability or registration of US trademarks. Be it, I remember one case we had deliberated on a couple of years ago on the whole trademark portfolio of Smapple being a trademark within Japan. It was registered under JETRO, and it completely superseded Apple's contention that it is an outright infringement, and they defied all basic laws to ensure that Smapple is registered and it is not contested. Similarly, they on the basis of proof of use for as big a brand as Jaguar and Land Rover, they've outrightly rejected their applicability. So I see there's a sense of a very strong feeling of not allowing US trademarks, especially the well-known brands, to enter the market. Do you think that has some rationale behind it, or is it purely premised on statutes?
No, so I would say, see, every trademark is dealt locally by the local law. So, I mean, I would rather say that Chinese people are Chinese authorities are more aggressive in that sense, because they are very inclined towards their locals, and it's where even I think there was a case of Apple as well, where Apple did not succeed against against a party who had already taken the Apple trademark. So, despite all the transport reputation, they were not able to secure a registration in China. So I do remember there was something like that. I don't remember the details right now. So I do believe it is it is totally about local laws, and I don't think powerhouses will try to thwart any other mark coming in for any other reason. It would it would be definitely if a mark is sort of registered in India as well, or some mark is applied in India by by an entity or a person who's residing out of India, it definitely does go through the protocols mentioned in the local laws. For example, even take the Madrid Protocol. If you were to apply for a trademark under the Madrid Protocol, like I always say, it is not a passport to registration. It's just a single filing process. It's a administrative relief that is given to you, and it does not mean that your mark will be automatically registered. It will still have to go through the provisions of the local law. So however well known you may be, however reputed you may be, if you're not able to convince the local authority that your mark is quite well known, it transcends all borders and it's well known in that territory, the authority has every right to reject registration to that mark as per their statutes. So I don't believe it's just a play of the local statute. And yes, I mean, there could be some other factors that they would want to give impetus to their local businesses. That is possible. Because trademark rights are territorial. So if at all you're giving a registration to a local party in Japan, it is for boosting that party's business in Japan or China, right? So also similarly for India. So yeah.
Absolutely. I think, that should have been the case. But when you read the arguments and the adjudications by the honorable courts, it at times appears that there are fundamental rationales of a generic or a descriptive trademark are being outrightly negated. And
we do keep getting these kind of I wouldn't say absurd or outrageous, but these shocking judgments from time to time. So if you would have read up the Booking.com judgment of US, where it talked
about to come to that,
where they talk about the registrability of a generic mark, a generic domain. So that principle sort of topples everything that you know about trademark law. While it was very the dissent was really good to read, but they went on the premise that, so what if it is generic? And, they went on to explain why they believe that a generic mark could be, given protection as well. So that really goes against the principles of trademark laws. But yes, you do getting from which are good to read, but I don't think that will be necessarily followed, widely.
Sure. Good you made mention of the Booking.com case. It's been a landmark judgment. And I wanted to particularly harp on this case as well. It has kind of really redefined the aspects of generic domain names coming to the picture. Although this appears to be a one-off case, you cannot actually bring it as a case law and have all generic names with a .com coming in across the world. It will create a havoc for sure. So yes, this case was utterly contested by tooth and nail right up to the Supreme Court in the US, and they tried every ounce of their rationale to outbeat the registrability, even harping on clauses from the competition laws that it would actually really thwart the entire the applicability in the whole industry. It'll deter competition. So, but yes, this is what fascinates as a practitioner or as a consultant. When you start reading these judgments, it evokes so much of intrigue that it becomes a trademark is as technical and as intriguing as patents or any other domains of IP. I keep harping on this fact. So, but brilliantly enunciated, Viji. Thank you so much. There is a couple of more aspects that I would want a quick opinion of yours in. One, circumventing around the entire e-commerce platform and the recent upgradations in terms of newer amendments in the statutes, the e-commerce bill, and the new e-commerce rules. How are you looking at it? Because it's also been a while. I think it's been a couple of years, the e-commerce bill being drafted and the e-commerce rules also now being applicable, including very, very pivotal requisites being put in. For example, one of the recent Delhi High Court judgments mandating a certificate of registration or certificate of authenticity for every brand owner dealing with the third parties on e-commerce platforms. So there have been a lot of instances that are reassuring from a consumer's perspective. How do you see from an FMCG perspective, if I may harp particularly on that aspect, please?
Yeah, so definitely the e-com business has, gained impetus, especially during the pandemic. It was anyways a fast-growing mode of business since the past few years, but there's really derived this impetus during pandemic, and I think most of us here definitely would have shifted, from an offline consumer to an online consumer. It also brings with it a host of other problems. While it is very good news for companies that are into this kind of business, they are leveraging their digital scale and all that, and most companies are getting into this business of B2B and B2C online platforms. It also brings with it a lot of problems in terms of counterfeit and fakes being sold on e-com very easily because of the anonymity that it provides to the seller, and because a seller can mask himself or herself or create multiple listing sites, so that is one major problem that comes with the e-commerce business, and this has been taken note of, and the government has become aware of this, and that is why we have recently had the e-commerce rules under the Consumer Protection Act. Of course, the e-commerce policy is yet to be launched. There were talks and there were drafts that were shared with the stakeholders, but that has not yet come into force, which sort of refines the processes within which, or the framework within which an e-com entity will operate. However, the consumer protection e-commerce rules also, it is a welcome move because it talks about certain guardrails that that are applicable to the e-com platform. In terms of, it imposes obligation on the e-com platform to have a grievance redressal mechanism, to have some kind of focal point for the consumers to raise its grievance, and it also talks about sharing information that it gets from its sellers, from a point of view of transparency, to sort of put it out on the website, etc. So a lot of good
Thank you very much for a very good presentation. Just I would like to know that many companies are registered their trademark, but practically they are not using. As you Viji said, there is a latest amendment. So what are their amendments when they are enforced? I just want to know.
Okay.
Viji, please take over. Yeah.
Sure. So the amendment is not on use. The amendment is on, filing evidence of use when you're claiming use while filing a trademark application. Say, for example, today I'm filing a trademark application for Dove, and I say that I've been using it since, say, 1980s, certain date, BDMMYY 1980, I need to file an affidavit saying that what I'm saying is correct. So your question is slightly different when you're saying that you have a trademark, probably you have registered it or applied for it and you've not used it. So there are already existing provisions in the Trademark Act which deals with cancellation of a trademark for non-use. So the way the law looks at it, see, ultimately any law, it is for the benefit of the consumer. Ultimately, it needs to come back into the larger pool for to be used by competition, right? So that we can, the consumer is served better. So if you have a mark that you have registered, but you have no intent to use it at all, and those are, if I'm not called, after 5 years, the law provides that after 5 years, they become clinically dead. It is of no use to you. You have no intent to use it. However, if you have an intent to use and you could not use it because there was some situation, say for example, if we take the pandemic situation, say, God forbid, but if it went on for 5 years, you had a trademark, you wanted to bring out a product under that brand, but you could not do so because of the pandemic, or there was some other governmental restriction, you have a valid point and you can prevail in any cancellation action when there is a challenge. But if you have a trademark, you have registered it and you're not using it at all, there is no intent to use, then that mark becomes dead and any other person can come and adopt that mark and start using it for his product. I mean, did that answer your question?
Thank you, Vijay. Interestingly, many of trademarks, many of companies are renewing, but they are not using. Every 10 years, they are renewing.
So anybody can
in that
challenge
case, anybody can
for non-use.
And one more thing, just I would like to know, we suppose somebody applied a trademark for a particular product. So later on, if they want to change to other product, same brand, I think it can possible. Am I correct?
Yes, it is possible, but there is a measure of due diligence that the brand owner must exercise. Because if I have to give an example, if I have to take the example of Lux, we use Lux for soaps and cosmetic products, but there is also a Lux brand which is used for clothing, right? So therefore, any other party you cannot have, if you see Supreme Court judgments and all that, unless your mark is so reputed that you can, there would be a dilution of your mark if somebody else uses that mark for some other products. Other people can use the same mark in relation to other products, especially if the mark is descriptive or not a coined mark. So for example, a mark like Kodak, probably, if somebody else wants to use it for a clothing line, Kodak can challenge that party saying that it's a coined mark. You cannot, even though I do not use it for clothes, you cannot use it for clothes because it's a coined mark. But if it is something like, say, for example, my own brand, Dove. Okay, if it is Dove, if somebody wants to use it for a clothing brand, probably he can, but if that's going to affect my business, I will go and challenge and say that Dove is so well known that, it would lead to some kind of confusion in the consumer's mind, because as an FMCG, I'm into so many diverse business, consumers will start thinking that I've also launched a clothing brand with Dove. Otherwise, if that is not the case, other companies can use, other entities or anybody else can use the same mark for other products. There is no stopping that.
Just to extend that, this aspect has been explicitly mentioned in the Indian Trademark Act, that for a well-known trademark, even with different goods and services, you cannot, or the well-known mark owner can actually thwart and resist any usage of its trademark in other goods and services as well. It's mandated. Yeah.
Thank you. The last question is.
Did that answer your question?
Yeah, ma'am. I would like to know, if somebody applied a trademark for a particular product that was abandoned, so later on, can I apply same type of product for again with same brand?
Okay. So again, like I said, due diligence would be required, because see, what a trademark registration gives you is only statutory right? Your common law right is not taken away. So today, if you see in the trademark registry that I had applied for a mark and it is abandoned, it does not necessarily mean that I'm not using the mark. A common law right is more superior sometimes even to a statutory right. Okay. So you need to be very sure that the party who has abandoned the mark is not using it also, so that, they do not have common law rights. So if you're very sure of that there is no statutory right, there is no common law right, and the mark is abandoned, of course you're free to adopt it. But that due diligence you will have to do.
In that case, ma'am, somebody may they may not file a trademark application also. That is also fine in that case.
That is also fine. Yes, you can use, and you need not, the law does not mandate a registration, but yes, it gives you certain privileges if you have registration.
Okay. Thank you very much.
Yeah, I think we'll just take quick couple of questions we have had from the audiences, Viji. One is pivoting around the fact of symbols. For example, the rupee symbol. Any trademark surrounding the standard rupee symbol mandated under the Indian government by the Indian government. Can that be a part of any composite trademark or any independent trademark? Do you believe?
No, that is, to the best of my knowledge, that is something that's an artwork which is created for the government, right? So the copyright in that will vest with the government. So you ideally should not be, claiming ownership on that rupee symbol, because it's not your property.
Absolutely. And I think the last question for the session, what we'll take is taste as a trademark or as a trademark domain, can it be registrable in India? I will just give you a prelude. I've recently read a case study from Europe again, wherein there was a Dutch company that has tried to trademark taste, and there have been an exemplary adjudication by the honorable courts at the regional level and then at the highest level as well, that taste per se is a very, very broad subject which will have a lot of conditions and contingencies attached. For example, perishability of goods, and taste is a subjective matter, and hence they have denied. From an Indian perspective, I have no clue. Please take the questions.
From an Indian perspective, we have a long way to go. Like I said, it's just recently that, sound marks were allowed in the amendment rules.
Yeah.
So taste, the problem with these kind of marks, like a taste mark, even probably a sound or a
fragrance,
fragrance. Yes, thank you. Fragrance or a single color mark is that, it has to really cross a lot of threshold. It's not like a regular trademark which automatically etches into the mind of the consumer. Like taste, fragrance, etc. They are so subjective. It differs from person to person. What is the criteria that we'll put? And under the Indian law, I think the major hurdle that we will have to get these marks, as registrable under the Indian law is that we have a requirement of graphical representation. How will you, at the time of filing a trademark application, how will you graphically represent a taste mark or a fragrance mark? So that is the major challenge. And then again, how will you enforce your rights in a taste mark or fragrance or whatever? How will you enforce your rights? So our systems need to be so evolved. Our codes and judiciary regulatory needs to be so evolved. They come out with certain standards for these kind of marks. And also the problem with non-traditional marks is that there are a lot of conditions for it to evolve into a proper trademark. For example, it cannot be functional. So if you ask me, if the taste is guided by certain function, say for example, if it is a medicine and you made it sweet, because medicine has to appeal to the person who is taking it, right? Because otherwise you're not going to have it in your mouth. So if that taste is aided by that functional requirement, that medicine has to appeal to you when you're taking it, then that becomes functional, and therefore it cannot be registered. So there are those kind of complexities that are connected with non-traditional trademarks. So I think it's a long way to go, and I would not say only India. There are only certain jurisdictions that have recognized certain non-traditional trademarks, like the US and the EU. But yes, not in all cases. There are very strict analysis on a case-to-case basis, and those marks have actually fulfilled those threshold in those regions. But if you ask me, in India, it will still take a long time. While we have evolved to a great extent with sound marks or probably single colors to some extent, but I think we have a long way to go.
Sure. I think you have encapsulated it absolutely brilliantly, and whilst we'd be so very wanting to continue for as long as we can, and to have you deliberate for so long is a pleasure and absolute honor for us, Viji. I think this has embarked a new series of discussions. I think once in 6 months I'll ensure that you are with us. And as we had discussed earlier, there are a lot of intriguing aspects on copyrights and designs in the fashion and media industry, jewelry, and it's extremely interesting to glean through those aspects as well. I'd be more than happy to have you in the next series of discussions. And for everyone, all the audiences, I sincerely thank you for your time. And for any further queries on trademarks, Viji and Khurana as a practitioners team, we're always there. Please feel free to reach out to us on LinkedIn. And Viji needs no recognition. She's being followed by millions, I must say now.
I didn't know that. Don't believe him. I didn't know that. So, and there may be
your
no
effective
truth to
following through the social media is humongous. I see all the HUL platforms across all domains, all platforms. Yeah. So thank you so much, everybody. Viji, again, thank you so much. I'll take this opportunity. Please keep blessing us with your rationales and your wisdom. Thank you so much. Hope to see you sometime sooner again.
Thank you, Shourabh, and
Brilliant.
Thank you, everyone, and Khurana. Thank you so much.
Thank you, people. Take care. Bye-bye.
Take care. Yeah.